New Jersey Real Estate Exam Broker Prep. Question 1. In a compliance audit, a person wants to qualify for a New Jersey real estate salesperson license. Which requirement must the applicant meet before licensure? Option A. Take only a continuing education course after receiving a license. Option B. Complete 150 hours of broker education and open an independent office. Option C. Complete the 75-hour pre-licensure course, pass the exam, and apply through a sponsoring broker. Option D. Pass the exam first and then decide later whether to affiliate with any broker. The correct answer is option C. Complete the 75-hour pre-licensure course, pass the exam, and apply through a sponsoring broker. A New Jersey salesperson applicant must satisfy education, examination, sponsorship, and character-related licensing requirements before practicing. Choice A is wrong because continuing education is for renewal, not initial salesperson qualification. Choice B is wrong because that applies to broker-level preparation, not the basic salesperson license. And choice D is wrong because a salesperson license is issued through an employing or sponsoring broker. Question 2. When reviewing closing papers, an experienced salesperson asks what is required to become a New Jersey broker. Which combination best matches the broker eligibility path? Option A. 1 year of part-time sales experience and a 75-hour course. Option B. 3 years of full-time salesperson experience plus 150 hours of approved broker education. Option C. A high school diploma only, if the applicant passes the state exam. Option D. A referral license and 6 months of office work. The correct answer is option B. 3 years of full-time salesperson experience plus 150 hours of approved broker education. Broker candidates are held to a higher standard because they may supervise brokerage activity and handle office responsibilities. Choice A is wrong because that resembles entry-level salesperson preparation and does not satisfy broker experience requirements. Choice C is wrong because education and approved experience are still required. And choice D is wrong because referral activity and office support do not replace the broker prerequisites. Question 3. Before meeting a client in Camden, a salesperson completes the pre-licensure course and receives examination eligibility. How long does that eligibility generally remain active? Option A. 30 days after the school certificate is issued. Option B. 1 year from the date it is issued. Option C. Indefinitely as long as the candidate keeps studying. Option D. 2 years after the course completion date. The correct answer is option B. 1 year from the date it is issued. New Jersey candidates must pass the examination and complete the licensing process within the applicable eligibility period. Choice A is wrong because that is too short for the standard eligibility period. Choice C is wrong because eligibility expires and does not remain open forever. And choice D is wrong because that overstates the eligibility window. Question 4. During a transaction in Hoboken, a public complaint alleges that a licensee violated real estate licensing law. Which body has regulatory authority over New Jersey real estate licensees? Option A. The New Jersey Real Estate Commission. Option B. The local board of education. Option C. The county tax assessor. Option D. The multiple listing service only. The correct answer is option A. The New Jersey Real Estate Commission. The New Jersey Real Estate Commission administers and enforces the state licensing law and related professional standards. Choice B is wrong because that agency does not regulate brokerage licenses. Choice C is wrong because tax assessment duties are separate from license discipline. And choice D is wrong because an MLS may set membership rules but does not issue state licenses. Question 5. In a brokerage file review, an applicant has completed education and passed the exam but has a serious character issue on the application. Which principle controls the licensing decision? Option A. Only the sponsoring broker decides whether the state issues the license. Option B. Character matters only after the first renewal. Option C. The commission must be satisfied with the applicant's honesty, trustworthiness, character, and integrity. Option D. Passing the exam automatically guarantees a license. The correct answer is option C. The commission must be satisfied with the applicant's honesty, trustworthiness, character, and integrity. Real estate licensing protects the public, so New Jersey considers more than classroom completion and test performance. Choice A is wrong because broker sponsorship is important but the commission makes licensing determinations. Choice B is wrong because character qualifications apply at initial licensure. And choice D is wrong because examination success does not eliminate character review. Question 6. For a duplex in Atlantic City, a new salesperson passes the exam and wants to start showing property immediately as an independent agent. Which action is required first? Option A. The candidate may collect commissions directly from clients before sponsorship. Option B. The candidate may practice alone for 90 days after passing. Option C. The candidate can use a friend's broker license temporarily. Option D. The candidate must complete licensure through an employing broker before practicing. The correct answer is option D. The candidate must complete licensure through an employing broker before practicing. A salesperson operates under a broker and cannot lawfully act independently before the licensing process is completed. Choice A is wrong because compensation must flow through the proper brokerage relationship. Choice B is wrong because passing the exam is not the same as holding an active license. And choice C is wrong because licenses are personal and cannot be borrowed. Question 7. While preparing a listing package, a broker candidate wants to schedule the broker examination before state approval of experience. What should the candidate understand? Option A. The candidate may skip the certificate if the employing broker signs a letter. Option B. The candidate only needs a salesperson pocket card at the test center. Option C. The candidate should wait for the certificate of examination eligibility before making the reservation. Option D. The candidate may schedule first and submit experience later. The correct answer is option C. The candidate should wait for the certificate of examination eligibility before making the reservation. Broker examination eligibility is controlled by the Commission's review of education and experience. Choice A is wrong because a broker's letter does not replace the state eligibility certificate. Choice B is wrong because broker candidates need the required eligibility documentation. And choice D is wrong because broker candidates must be approved before making the broker exam reservation. Question 8. At a salesperson training session, a salesperson receives a referral fee offered directly from a mortgage lender for sending a buyer. How should the salesperson respond? Option A. Ask the lender to label the payment as a gift. Option B. Deposit the fee into a personal account and disclose it later. Option C. Refuse direct compensation and follow compensation rules through the employing broker. Option D. Accept the payment personally if the buyer consents. The correct answer is option C. Refuse direct compensation and follow compensation rules through the employing broker. A salesperson's real estate compensation must be handled through the supervising broker and cannot be taken directly from outside parties. Choice A is wrong because renaming compensation does not cure an improper payment. Choice B is wrong because personal receipt of unauthorized compensation violates compensation rules. And choice D is wrong because buyer consent does not authorize compensation outside the broker relationship. Question 9. After receiving an offer in Asbury Park, a broker is reviewing supervision duties for affiliated salespersons. Which statement best describes the broker's responsibility? Option A. Salespersons supervise themselves once licensed. Option B. The broker must supervise licensed activity performed through the brokerage. Option C. Supervision applies only to commercial deals. Option D. Only the office manager is responsible for legal compliance. The correct answer is option B. The broker must supervise licensed activity performed through the brokerage. A broker is responsible for the brokerage operation and for ensuring affiliated licensees follow applicable law and office procedures. Choice A is wrong because salespersons act under broker supervision. Choice C is wrong because broker supervision covers brokerage activity generally. And choice D is wrong because delegation does not remove the broker's responsibility. Question 10. During an agency disclosure conversation, a buyer gives earnest money to a listing broker in a purchase transaction. Where should money belonging to others be placed? Option A. In the broker's personal checking account. Option B. In the salesperson's desk until closing. Option C. In the seller's account before acceptance. Option D. In a separate broker escrow or trust account maintained for funds of others. The correct answer is option D. In a separate broker escrow or trust account maintained for funds of others. Trust funds must be safeguarded separately from the broker's personal and operating funds. Choice A is wrong because that would mix client funds with personal money. Choice B is wrong because a salesperson should promptly account for and deliver funds to the broker. And choice C is wrong because the seller is not automatically entitled to the buyer's deposit before proper disbursement. Question 11. In a compliance audit, a deposit is received while negotiations are expected to continue beyond 5 business days. How should the licensee handle the money? Option A, hold it uncashed until all negotiations are finished. Option B, deposit it into the broker's operating account. Option C, deliver it to the broker so it can be deposited into the trust account within the required time. Option D, give it to the listing salesperson for safekeeping. The correct answer is option C, deliver it to the broker so it can be deposited into the trust account within the required time. When negotiations continue beyond the short statutory window, funds of others must be promptly segregated into the broker's trust account. Choice A is wrong because ongoing negotiations do not allow indefinite personal holding of the deposit. Choice B is wrong because operating accounts are not trust accounts for money of others. And choice D is wrong because salespersons do not maintain trust accounts for client deposits. Question 12. When reviewing closing papers, a broker places client earnest money into the same account used to pay office rent. Which violation is most directly shown? Option A, commingling. Option B, redlining. Option C, is cheat. Option D, blockbusting. The correct answer is option A, commingling. Commingling occurs when money of others is mixed with the broker's own business or personal funds. Choice B is wrong because redlining involves discriminatory lending or service patterns by area. Choice C is wrong because as cheat is the government's power to take property when an owner dies without heirs. And choice D is wrong because blockbusting involves inducing panic selling based on protected class changes. Question 13. Before meeting a client in Patterson, a broker intentionally uses escrow funds to pay a personal credit card bill. Which violation best describes this conduct? Option A, conversion. Option B, accretion. Option C, novation. Option D, variance. The correct answer is option A, conversion. Conversion is the wrongful taking or use of another person's money or property for one's own purpose. Choice B is wrong because accretion is a gradual addition to land by natural forces. Choice C is wrong because novation replaces a party or obligation in a contract and is not misuse of funds. And choice D is wrong because a variance is zoning relief, not taking another person's money. Question 14. During a transaction in Trenton, a broker is authorized to take a commission from trust funds after it is earned. What must the broker do to avoid commingling? Option A, withdraw the commission from the trust account within the required time after it becomes payable. Option B, leave the commission in escrow as a savings reserve. Option C, pay the commission directly to the salesperson from escrow. Option D, transfer all trust funds to the operating account. The correct answer is option A, withdraw the commission from the trust account within the required time after it becomes payable. Once money becomes the broker's earned commission, it should not remain in the trust account as though it were still client money. Choice B is wrong because earned broker funds should not remain mixed with trust funds. Choice C is wrong because salesperson compensation should be handled through the brokerage's proper accounting process. And choice D is wrong because client funds cannot be moved improperly to a business account. Question 15. In a brokerage file review, a licensee has an ownership interest in property being sold through the brokerage. What disclosure is required? Option A. The licensee's interest should be disclosed to the purchaser in the contract of sale. Option B. Disclosure is needed only after closing. Option C. No disclosure is needed if the price is fair. Option D. Only the lender needs to know. The correct answer is option A. The licensee's interest should be disclosed to the purchaser in the contract of sale. A licensee acting as a principal or having an ownership interest must disclose that conflict so the other party can make an informed decision. Choice B is wrong because the buyer must know before being bound to the transaction. Choice C is wrong because fair price does not remove the conflict of interest. And choice D is wrong because the purchaser is the party affected by the licensee's ownership interest. Question 16. For a duplex in Hoboken, a salesperson wants to advertise a property exclusively listed by another brokerage. Which condition must be satisfied first? Option A. Prior written consent from the listing broker must be obtained. Option B. The salesperson may advertise it if the price is public. Option C. Consent from any buyer is enough. Option D. No consent is required for social media posts. The correct answer is option A. Prior written consent from the listing broker must be obtained. Exclusive listings cannot be advertised by another brokerage without proper authorization from the listing broker. Choice B is wrong because public price information does not authorize another broker's advertising. Choice C is wrong because the listing broker controls the exclusive listing advertising permission. And choice D is wrong because online advertising is still advertising subject to the rules. Question 17. While preparing a listing package, a salesperson creates a social media ad for a listing. Which identification should appear in the advertisement? Option A. Only the property address. Option B. Only the salesperson's nickname. Option C. The salesperson's licensed name and the regular business name of the broker through whom the salesperson is licensed. Option D. Only a personal cell phone number. The correct answer is option C. The salesperson's licensed name and the regular business name of the broker through whom the salesperson is licensed. New Jersey advertising rules require clear identification of the licensed person and the brokerage business name. Choice A is wrong because property information does not identify the brokerage authority. Choice B is wrong because ads must identify the licensed individual and broker appropriately. And choice D is wrong because contact information alone does not satisfy brokerage identification rules. Question 18. At a salesperson training session, a salesperson's advertisement shows the salesperson name in huge type and the broker's name in small print. Which issue is raised? Option A. The broker's regular business name must appear more prominently than the non-broker licensee's name. Option B. The ad is valid because the salesperson paid for it. Option C. The ad is valid if the property sells quickly. Option D. The ad is invalid only if it contains a price. The correct answer is option A. The broker's regular business name must appear more prominently than the non-broker licensee's name. Advertising must make the brokerage relationship clear to the public rather than presenting a salesperson as the brokerage. Choice B is wrong because payment for an ad does not change the prominence rule. Choice C is wrong because sales success does not cure an advertising violation. And choice D is wrong because the broker identification rule is not limited to price advertisements. Question 19. After receiving an offer in Morristown, an ad states that the brokerage is licensed by the New Jersey Real Estate Commission. What additional message is generally required? Option A. A notice that the salesperson is an attorney. Option B. A statement that commissions are fixed by law. Option C. A promise that the commission guarantees the property condition. Option D. A clear statement that licensure does not imply endorsement. The correct answer is option D. A clear statement that licensure does not imply endorsement. A reference to commission licensure cannot be presented as though the state endorses the licensee's services. Choice A is wrong because attorney status is unrelated unless it is actually true and relevant. Choice B is wrong because commission rates are not fixed and such a claim would be misleading. And choice C is wrong because the commission does not guarantee listed property quality. Question 20. During an agency disclosure conversation, an advertisement mentions the brokerage's commission rate. Which statement should also be included in New Jersey? Option A. Only sellers may negotiate commission. Option B. In New Jersey, commissions are negotiable. Option C. Commission is due even if no brokerage agreement exists. Option D. All commissions are set by the Real Estate Commission. The correct answer is option B. In New Jersey, commissions are negotiable. New Jersey requires transparency when commission rates or fees are advertised so consumers are not misled into believing rates are fixed. Choice A is wrong because compensation arrangements may involve different parties depending on the agreement. Choice C is wrong because compensation depends on the applicable agreement and law. And choice D is wrong because commission rates are not government fixed. Question 21. In a compliance audit, a referral agent prepares marketing materials for the public. Which limitation should be made clear? Option A. The referral agent may supervise salespersons. Option B. The referral agent may negotiate contracts alone. Option C. The services are limited to referring prospects to a broker. Option D. The referral agent may hold escrow deposits. The correct correct answer is option C. Services are limited to referring prospects to a broker. A referral license is limited and should not be presented as full brokerage representation. Choice A is wrong because supervision is a broker-level responsibility. Choice B is wrong because negotiation is licensed brokerage activity beyond referral-only status. And choice D is wrong because referral status does not authorize trust fund handling. Question 22. When reviewing closing papers, an unlicensed assistant is asked to host an open house, answer price questions, and negotiate offers. Which task creates the greatest licensing problem? Option A. Negotiating offers with buyers or sellers. Option B. Typing a broker-approved flyer. Option C. Scheduling a showing without giving advice. Option D. Ordering office supplies. The correct answer is option A. Negotiating offers with buyers or sellers. Negotiating real estate terms is licensed brokerage activity and cannot be performed by an unlicensed assistant. Choice B is wrong because pure clerical support can be permissible when properly supervised. Choice C is wrong because ministerial scheduling is different from negotiation. And choice D is wrong because clerical purchasing does not require a real estate license. Question 23. Before meeting a client in Newark, a broker is deciding how long transaction files and escrow records should be kept. Which compliance principle is most important? Option A. Destroy records immediately after commission is paid. Option B. Let each salesperson keep the only file copy. Option C. Maintain required records so the commission can review brokerage activity and trust accounting. Option D. Keep only text messages but no contracts. The correct answer is option C. Maintain required records so the commission can review brokerage activity and trust accounting. Record keeping supports supervision, audits, consumer protection, and proof of proper handling of funds and documents. Choice A is wrong because paid commission does not end record keeping duties. Choice B is wrong because brokerage records must be under responsible brokerage control. And choice D is wrong because contracts and financial records are central brokerage documents. Question 24. During a transaction in Jersey City, a broker's trust ledger does not match the bank balance and no reconciliation is performed. Which area is most directly at risk? Option A. Zoning variance approval. Option B. Appraisal licensing. Option C. A land measurement. Option D. Escrow account bookkeeping compliance. The correct answer is option D. Escrow account bookkeeping compliance. Trust account records must accurately track client funds so shortages, overages, and improper disbursements can be detected. Choice A is wrong because local land use relief is not the same as broker trust accounting. Choice B is wrong because value opinions do not correct escrow bookkeeping failures. And choice C is wrong because survey or measurement issues are unrelated to trust ledger accuracy. Question 25. In a brokerage file review, a consumer loses money because a licensee unlawfully converts funds in a brokerage transaction. Which New Jersey protection may be relevant? Option A. The Real Estate Guarantee Fund. Option B. A homeowners association reserve. Option C. A zoning board escrow. Option D. Private mortgage insurance. The correct answer is option A. The Real Estate Guarantee Fund. The Real Estate Guarantee Fund provides a potential recovery source for certain losses caused by embezzlement, conversion, or unlawful obtaining of property in brokerage transactions. Choice B is wrong because association reserves are for community expenses, not brokerage misconduct claims. Choice C is wrong because zoning boards do not reimburse brokerage fraud losses. And choice D is wrong because PMI protects a lender against borrower default, not a consumer from licensee conversion. Question 26. For a duplex in Trenton, a developer markets out-of-state subdivision interests to New Jersey purchasers. Which New Jersey law is most likely relevant? Option A. The Equal Credit Opportunity Act only. Option B. The Farmland Assessment Act only. Option C. The Truth in Renting Act only. Option D. The New Jersey Real Estate Sales Full Disclosure Act. The correct answer is option D. The New Jersey Real Estate Sales Full Disclosure Act. The Real Estate Sales Full Disclosure Act regulates certain real estate offerings marketed in New Jersey, including interests located outside the state. Choice A is wrong because ECOA addresses credit discrimination, not registration of out-of-state offerings. Choice B is wrong because farmland assessment deals with property tax treatment. and choice C is wrong because that law concerns rental disclosures rather than marketing subdivided land interests. Question 27. While preparing a listing package, a landlord refuses to rent to an otherwise qualified applicant because the applicant uses a lawful housing voucher. Which New Jersey rule is implicated? Option A. The rule of capture. Option B. The rule against fixtures. Option C. The statute of frauds only. Option D. The New Jersey law against discrimination protection for lawful source of income or rent payment. The correct answer is option D. The New Jersey law against discrimination protection for lawful source of income or rent payment. New Jersey fair housing protections include lawful source of income or rent payment in housing transactions. Choice A is wrong because that doctrine concerns natural resources, not rental screening. Choice B is wrong because fixture law concerns personal versus real property, not discrimination. And choice C is wrong because contract writing rules do not authorize source of income discrimination. Question 28. At a salesperson training session, an agent guides buyers away from a neighborhood because of the buyer's national origin. Which prohibited practice is this? Option A. Accession. Option B. Puffing. Option C. Defeasance. Option D. Steering. The correct answer is option D. Steering. Steering occurs when a housing professional directs or limits choices because of a protected characteristic. Choice A is wrong because accession concerns ownership of added property, not discriminatory guidance. Choice B is wrong because puffing is exaggerated opinion and does not describe directing buyers based on protected status. And choice C is wrong because defeasance is a mortgage clause, not fair housing misconduct. Question 29. After receiving an offer in Princeton, a licensee tells homeowners that people of a certain protected class are moving nearby and they should sell quickly. Which violation is shown? Option A. Redemption. Option B. Blockbusting. Option C. Assemblage. Option D. Subordination. The correct answer is option B. Blockbusting. Blockbusting uses fear or prejudice to induce sales or listings and is prohibited under fair housing principles. Choice A is wrong because redemption concerns reclaiming property after default or foreclosure in certain contexts. Choice C is wrong because assemblage combines parcels and is not a fair housing violation. And choice D is wrong because subordination changes lien priority and is not panic selling. Question 30. During an agency disclosure conversation, a lender refuses to make loans in neighborhoods with high minority populations regardless of applicant qualifications. Which term best describes this conduct? Option A. Hypothecation. Option B. Reconciliation. Option C. Redlining. Option D. Prioration. The correct answer is option C. Redlining. Redlining is the discriminatory denial or restriction of credit or services based on neighborhood characteristics tied to protected classes. Choice A is wrong because hypothecation pledges property as security while retaining possession. Choice B is wrong because reconciliation is an appraisal step, not discriminatory lending geography. And choice D is wrong because prioration divides expenses at closing and does not describe lending discrimination. Question 31. In a compliance audit, a landlord refuses to rent to families with children unless the property qualifies for a lawful senior housing exception. Which protected category is involved? Option A. Tenancy in common. Option B. Subrogation. Option C. Accretion. Option D. Familial status. The correct answer is option D. Familial status. Familial status protects households with children from discriminatory housing treatment unless a narrow legal exception applies. Choice A is wrong because that is an ownership form, not a fair housing class. Choice B is wrong because subrogation is an insurance concept, not discrimination law. And choice C is wrong because accretion concerns land created by natural deposits. Question 32. When reviewing closing papers, a tenant with a disability requests permission to keep an assistance animal despite a no-pets policy. Which response is most consistent with fair housing principles? Option A. Approve only if every tenant votes yes. Option B. Charge a higher security deposit solely because of the disability. Option C. Deny it because all animal requests are identical to pet ownership. Option D. Evaluate the request as a reasonable accommodation rather than automatically denying it as a pet violation. The correct answer is option D. Evaluate the request as a reasonable accommodation rather than automatically denying it as a pet violation. A disability-related accommodation may require an exception to ordinary rules when it is reasonable and necessary. Choice A is wrong because fair housing rights are not subject to a popularity vote. Choice B is wrong because differential charges based on disability can be discriminatory. And choice C is wrong because assistance animal requests can be disability accommodations. Question 33. Before meeting a client in Asbury Park, a seller asks the listing agent not to disclose a known structural defect to buyers. Which duty is most important? Option A. Wait until after closing to mention the defect. Option B. Follow the seller's instruction because loyalty always overrides disclosure. Option C. Disclose only to the appraiser and not to buyers. Option D. Material facts and known defects should be disclosed as required by law and professional duties. The correct answer is option D. Material facts and known defects should be disclosed as required by law and professional duties. Licensees owe honesty and disclosure duties that prevent concealment of material property facts. Choice A is wrong because post-closing disclosure is too late for informed buyer decision-making. Choice B is wrong because loyalty does not permit concealment of material facts. And choice C is wrong because buyers are directly affected by the property condition. Question 34. During a transaction in Montclair, an agent representing a seller also wants to represent the buyer in the same transaction. What is generally required for disclosed dual agency? Option A. Informed consent from both parties after proper disclosure. Option B. No consent because dual agency is always automatic. Option C. Only the seller's verbal permission. Option D. A lender's approval instead of client consent. The correct answer is option A. Informed consent from both parties after proper disclosure. Dual agency creates divided loyalty, so both parties must understand and consent to the relationship. Choice B is wrong because dual agency is not automatic and requires disclosure and consent. Choice C is wrong because both clients are affected by dual representation. And choice D is wrong because lender approval does not replace the parties' informed agency consent. Question 35. In a brokerage file review, two agents in the same brokerage are assigned separately to a buyer and a seller with appropriate consent. Which relationship is being used? Option A. Tenancy at sufferance. Option B. Redlining. Option C. Designated agency. Option D. Novation. The correct answer is option C. Designated agency. Designated agency allows different licensees within one brokerage to represent different clients when the required disclosures and consents are handled. Choice A is wrong because that term describes occupancy after a lease ends, not brokerage representation. Choice B is wrong because redlining is discriminatory lending or service practice. And choice D is wrong because novation replaces a party or obligation in a contract. Question 36. For a duplex in Jersey City, a broker helps both sides with paperwork but does not advocate as either party's fiduciary. Which relationship best fits that limited role? Option A. Universal agent with unlimited authority. Option B. Mortgagee. Option C. Transaction broker or facilitator. Option D. Life tenant. The correct answer is option C. Transaction broker or facilitator. A transaction broker or facilitator assists with the transaction without becoming a full fiduciary advocate for one party. Choice A is wrong because a universal agent has broad authority that does not match a neutral facilitation role. Choice B is wrong because a mortgagee is the lender, not a neutral transaction facilitator. And choice D is wrong because a life tenant holds a property interest, not a brokerage relationship. Question 37. While preparing a listing package, a buyer asks whether a brokerage services agreement is needed before the licensee works with the buyer. Which answer best reflects current New Jersey consumer protection practice? Option A. Only sellers can have brokerage agreements. Option B. A written brokerage services agreement is generally required when providing brokerage services to the buyer. Option C. A written agreement is never needed for buyers. Option D. An oral handshake is always enough. The correct answer is option B. A written brokerage services agreement is generally required when providing brokerage services to the buyer. Written brokerage agreements improve transparency about services, representation, and compensation before the licensee works with a buyer. Choice A is wrong because buyers may also enter brokerage service agreements. Choice C is wrong because current practice requires written agreements in buyer service situations. and choice D is wrong because consumer protection rules emphasize written disclosure and agreement. Question 38. At a salesperson training session, a licensee owes obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care to a client. Which concept is being tested? Option A, substitution. Option B, this cheat. Option C, police power. Option D, fiduciary duties. The correct answer is option D, fiduciary duties. Fiduciary duties define the high level of care and loyalty an agent owes to a client. Choice A is wrong because substitution is not the standard term for client fiduciary obligations. Choice B is wrong because escheat is a government right involving ownerless property. And choice C is wrong because police power is government regulation for public welfare. Question 39. After receiving an offer in Camden, a licensee is working with a customer rather than a client. Which duty still applies? Option A, permission to misstate property condition. Option B, undivided loyalty as a fiduciary client. Option C, honesty and fair dealing with disclosure of known material facts. Option D, authority to sign contracts for the customer. The correct answer is option C, honesty and fair dealing with disclosure of known material facts. Even without a client-fiduciary relationship, licensees must deal honestly and avoid concealing material information. Choice A is wrong because customer status does not allow misrepresentation. Choice B is wrong because customers are not owed the full fiduciary loyalty owed to clients. And choice D is wrong because a licensee needs proper legal authority to sign for another person. Question 40. During an agency disclosure conversation, a buyer submits an offer and the seller responds by changing the price and closing date. What is the seller's response? Option A, an acceptance of the original offer. Option B, a counteroffer that rejects the original offer and proposes new terms. Option C, a deed restriction. Option D, an appraisal report. The correct answer is option B, a counteroffer that rejects the original offer and proposes new terms. A counteroffer changes proposed terms and usually terminates the offeree's power to accept the original offer. Choice A is wrong because changing material terms prevents the response from being an acceptance. Choice C is wrong because a deed restriction limits property use and is not an offer response. And choice D is wrong because an appraisal estimates value and does not form contract terms. Question 41. In a compliance audit, a valid real estate purchase contract is being reviewed. Which element is essential? Option A, an MLS number without parties or price. Option B, only a handshake and a property photo. Option C, mutual assent, competent parties, lawful purpose, consideration, and sufficiently definite terms. Option D, a notarized deed before any agreement. The correct answer is option C, mutual assent, competent parties, lawful purpose, consideration, and sufficiently definite terms. A valid contract requires agreement and legally sufficient elements, not just informal interest in a property. Choice A is wrong because an MLS reference alone does not establish contract obligations. Choice B is wrong because real estate contracts generally require more definite and documented terms. And choice D is wrong because a deed transfers title and is separate from forming a purchase contract. Question 42. When reviewing closing papers, an offer states that acceptance must be communicated by 5 p.m. Friday. When does acceptance generally become effective? Option A, only after the deed is recorded. Option B, when the buyer privately decides to accept. Option C, when the seller starts thinking about the offer. Option D, when the acceptance is properly communicated according to the offer's terms. The correct answer is option D, when the acceptance is properly communicated according to the offer's terms. Contract formation generally requires objective acceptance communicated in the manner required by the offer. Choice A is wrong because recording relates to title notice, not contract acceptance. Choice B is wrong because private intent does not notify the offerer. And choice C is wrong because consideration of an offer is not acceptance. Question 43. Before meeting a client in Morristown, an agreement for the sale of real estate is made orally with no sufficient writing. Which doctrine is most likely involved? Option A, principle of substitution. Option B, rule against perpetuities. Option C, statute of frauds. Option D, doctrine of emblements. The correct answer is option C, statute of frauds. The statute of frauds generally requires real estate sale contracts to be in writing to be enforceable. Choice A is wrong because substitution is an appraisal principle, not a contract writing requirement. Choice B is wrong because that doctrine concerns remote future interests, not the writing requirement for sales contracts. And choice D is wrong because emblements concern crops grown by a tenant. Question 44. During a transaction in Edison, a purchase agreement says the buyer may cancel if financing is not approved by a stated date. What is this clause? Option A. A quitclaim deed. Option B. A tax assessment appeal. Option C. A deed covenant of season. Option D. A contingency. The correct answer is option D. A contingency. A contingency makes performance or continued obligation depend on a stated event or condition. Choice A is wrong because a quitclaim deed transfers whatever interest the grantor has. Choice B is wrong because an assessment appeal challenges value for taxation. And choice C is wrong because that deed covenant concerns ownership title, not a condition in a purchase agreement. Question 45. In a brokerage file review, a contract states that deadlines are strict and late performance may be a breach. Which phrase expresses that idea? Option A. Time is of the essence. Option B. Quiet enjoyment. Option C. Caveat emptor. Option D. Highest and best use. The correct answer is option A. Time is of the essence. The phrase time is of the essence makes timely performance a material contract requirement. Choice B is wrong because quiet enjoyment protects possession from interference, not deadline strictness. Choice C is wrong because that phrase means buyer beware and does not make deadlines strict. And choice D is wrong because that valuation concept concerns the most profitable legal use. Question 46. For a duplex in Montclair, a seller breaches a valid purchase contract and the buyer wants the court to require transfer of the unique property. Which remedy is the buyer seeking? Option A. Assemblage. Option B. Specific performance. Option C. Amortization. Option D. Subletting. The correct answer is option B. Specific performance. Specific performance asks a court to enforce the exact contractual promise, often because real estate is considered unique. Choice A is wrong because assemblage combines parcels for development. Choice C is wrong because amortization is loan repayment over time. And choice D is wrong because subletting transfers a tenant's possession interest to another occupant. Question 47. While preparing a listing package, a seller grants a buyer the exclusive right to purchase property within 60 days while the seller must keep the offer open. What agreement is this? Option A. An option contract. Option B. A gross lease. Option C. A blanket mortgage. Option D. A release deed. The correct answer is option A. An option contract. An option gives the holder the right, but not the obligation, to buy or lease under stated terms during the option period. Choice B is wrong because a gross lease concerns rent and operating expenses. Choice C is wrong because a blanket mortgage covers more than one parcel as security. And choice D is wrong because a release deed removes or gives up a claim or interest. Question 48. At a salesperson training session, a kitchen chandelier is physically attached, intended to stay, and adapted to the room. How is it most likely classified? Option A. Emblement. Option B. Trade fixture of a tenant. Option C. Personal property that always remains with the seller. Option D. Fixture. The correct answer is option D. Fixture. A fixture is personal property that has become part of the real estate through attachment, adaptation, and intent. Choice A is wrong because emblements are cultivated crops. Choice B is wrong because a residential seller's chandelier is not usually a tenant business fixture. And choice C is wrong because attached items intended to stay often become real property. Question 49. After receiving an offer in Patterson, two unrelated buyers own unequal shares of property and each share can pass by will. Which ownership form is most likely? Option A. Joint tenancy with automatic survivorship. Option B. Tenancy in common. Option C. A leasehold estate only. Option D. Severalty. The correct answer is option B. Tenancy in common. Tenants in common may own unequal shares and each owner's interest can pass through that owner's estate. Choice A is wrong because joint tenancy includes survivorship and usually equal ownership interests. Choice C is wrong because a leasehold is a possessory right under a lease, not co-ownership of title. and choice D is wrong because severalty means ownership by one person or entity alone. Question 50. During an agency disclosure conversation, two owners want the surviving owner to automatically receive the deceased owner's interest. Which ownership feature is needed? Option A, severalty. Option B, divulsion. Option C, right of survivorship. Option D, deficiency judgment. The correct answer is option C, right of survivorship. Right of survivorship causes a deceased co-owner's interest to pass automatically to the surviving co-owner or co-owners. Choice A is wrong because severalty involves one owner and no co-owner survivorship. Choice B is wrong because avulsion is a sudden natural change in land. And choice D is wrong because a deficiency judgment follows insufficient foreclosure sale proceeds. Question 51. In a compliance audit, a person receives possession and use of property for the duration of another person's life. Which estate is described? Option A, periodic tenancy. Option B, life estate. Option C, fee simple absolute. Option D, easement in gross. The correct answer is option B, life estate. A life estate lasts only for the lifetime of a named person and then ends or passes to the future interest holder. Choice A is wrong because periodic tenancy is a leasehold that renews for successive periods. Choice C is wrong because fee simple absolute is the broadest ownership estate and is not limited by a measuring life. And choice D is wrong because an easement is a use right, not a possessory estate for life. Question 52. When reviewing closing papers, a buyer purchases an individual unit and an undivided interest in common areas. Which form of ownership is most likely involved? Option A, cooperative ownership only. Option B, condominium ownership. Option C, easement by necessity. Option D, license only. The correct answer is option B, condominium ownership. Condominium owners hold title to their units plus a shared interest in common elements. Choice A is wrong because a cooperative usually involves shares in a corporation and a proprietary lease. Choice C is wrong because that easement provides access and does not create unit ownership. And choice D is wrong because a license is permission rather than ownership of a unit. Question 53. Before meeting a client in Princeton, a driveway easement benefits a neighboring parcel and transfers with that parcel. Which type of easement is this? Option A, easement in gross for a person only. Option B, encroachment. Option C, easement appurtenant. Option D, a mechanic's lien. The correct answer is option C, easement appurtenant. An easement appurtenant benefits land and generally runs with the benefited parcel when ownership changes. Choice A is wrong because an easement in gross benefits a person or entity rather than a parcel. Choice B is wrong because an encroachment is an unauthorized physical intrusion. And choice D is wrong because a mechanic's lien secures payment for labor or materials. Question 54. During a transaction in Atlantic City, a neighbor's garage extends 2 feet onto another owner's land. Which title issue is most likely present? Option A, functional obsolescence. Option B, novation. Option C, eminent domain. Option D, encroachment. The correct answer is option D, encroachment. An encroachment occurs when an improvement extends onto another's property without proper right. Choice A is wrong because functional obsolescence is a valuation issue related to design or utility. Choice B is wrong because novation substitutes a new party or obligation in a contract. And choice C is wrong because eminent domain is a government taking for public use. Question 55. In a brokerage file review, a contractor records a claim against property because the owner did not pay for improvements. Which encumbrance is most likely? Option A, variance. Option B, license. Option C, literal right. Option D, a mechanic's lien. The correct answer is option D, mechanic's lien. A mechanic's lien can secure payment for labor or materials furnished to improve real property. Choice A is wrong because a variance is zoning permission to deviate from rules. Choice B is wrong because a license is permission to use property and does not secure payment. And choice C is wrong because literal rights relate to property bordering large bodies of water. Question 56. For a duplex in Edison, a legal description begins at a point of beginning and follows directions and distances around the parcel. Which description method is being used? Option A, street address only. Option B, lot and block. Option C, datum reference only. Option D, meets and bounds. The correct answer is option D, meets and bounds. Meets and bounds descriptions use boundary lines, angles, distances, and a point of beginning. Choice A is wrong because a street address is not the most reliable legal description. Choice B is wrong because lot and block refers to recorded subdivision map identifiers. And choice C is wrong because a datum is an elevation reference, not a complete boundary description. Question 57. While preparing a listing package, a deed identifies property as Lot 12, Block 8 on a recorded subdivision map. Which legal description method is this? Option A, government rectangular survey only. Option B, informal address description. Option C, meets and bounds. Option D, lot and block. The correct answer is option D, lot and block. Lot and block descriptions identify parcels by reference to a recorded plat or subdivision map. Choice A is wrong because that system uses principal meridians, baselines, townships, and ranges. Choice B is wrong because a recorded lot and block is more formal than a street address. And choice C is wrong because meets and bounds relies on courses and distances from a point of beginning. Question 58. At a salesperson training session, a municipality adopts zoning rules to control land use for public welfare. Which government power is being exercised? Option A, police power. Option B, this cheat. Option C, eminent domain. Option D, taxation. The correct answer is option A, police power. Zoning is a classic exercise of police power because it regulates land use to protect health, safety, and welfare. Choice B is wrong because this cheat applies when property has no lawful owner or heirs. Choice C is wrong because eminent domain involves taking property for public use with compensation. And choice D is wrong because taxation raises revenue rather than directly regulating land use patterns. Question 59. After receiving an offer in Newark, the government takes private land for a highway project and pays just compensation. Which power is being used? Option A, accretion. Option B, eminent domain. Option C, private restriction. Option D, this cheat. The correct answer is option B, eminent domain. Eminent domain allows government to take private property for public use when just compensation is paid. Choice A is wrong because accretion is land buildup from natural causes. Choice C is wrong because private restrictions are created by deeds or covenants, not government takings. And choice D is wrong because this cheat deals with ownerless property or lack of heirs. Question 60. During an agency disclosure conversation, a property owner dies intestate with no heirs, and the property passes to the state. Which government right applies? Option A, condemnation. Option B, police power. Option C, special assessment. Option D, this cheat. The correct answer is option D, is cheat. Is cheat prevents property from remaining ownerless when there are no lawful heirs. Choice A is wrong because condemnation is the legal process used in eminent domain. Choice B is wrong because police power regulates property use rather than transferring ownerless property. And choice C is wrong because a special assessment pays for a public improvement benefiting property. Question 61. In a compliance audit, a subdivision deed says homes may not be used for commercial auto repair. What type of private control is this? Option A, a title abstract. Option B, a deficiency judgment. Option C, a deed restriction or covenant. Option D, a tax prioration. The correct answer is option C, a deed restriction or covenant. Private deed restrictions and covenants limit how property may be used even when public zoning would otherwise permit the use. Choice A is wrong because a title abstract summarizes recorded title history. Choice B is wrong because a deficiency judgment seeks unpaid debt after foreclosure sale proceeds are insufficient. And choice D is wrong because tax prioration allocates taxes at closing. Question 62. When reviewing closing papers, a buyer considers land in a mapped flood area and near regulated wetlands. Which issue should trigger extra investigation? Option A, land use and environmental restrictions that may limit development. Option B, guaranteed mortgage approval. Option C, automatic exemption from all zoning. Option D, immediate title transfer without due diligence. The correct answer is option A, land use and environmental restrictions that may limit development. Flood zones and wetlands can affect insurance, development approvals, and lawful use of property. Choice B is wrong because environmental concerns do not guarantee financing. Choice C is wrong because environmentally sensitive land is often more regulated, not exempt, and choice D is wrong because special land conditions usually require more review, not less. Question 63. Before meeting a client in Camden, a salesperson prepares a pricing opinion for a seller using recently sold comparable homes. What is the salesperson most likely preparing? Option A, a zoning ordinance. Option B, a comparative market analysis. Option C, a certified appraisal. Option D, a deed of trust. The correct answer is option B, a comparative market analysis. A comparative market analysis helps estimate a likely listing or sale price using market data but is not a licensed appraisal. Choice A is wrong because a zoning ordinance is a government land use rule. Choice C is wrong because a CMA is not the same as a formal appraisal by a certified appraiser. And choice D is wrong because a deed of trust is a financing security instrument in some states. Question 64. During a transaction in Hoboken, an appraiser estimates value by comparing the subject property to recently sold similar properties. Which approach is being used? Option A, subdivision approach. Option B, cost approach. Option C, income approach. Option D, sales comparison approach. The correct answer is option D, sales comparison approach. The sales comparison approach is based on substitution and uses comparable sales adjusted for differences. Choice A is wrong because that is a specialized development analysis, not the standard comparable sales method. Choice B is wrong because the cost approach estimates land value plus replacement or reproduction cost less depreciation, and choice C is wrong because the income approach converts income into value. Question 65. In a brokerage file review, an investor's apartment building is valued by converting net operating income into value. Which appraisal approach is being used? Option A, income approach. Option B, sales comparison only. Option C, assessed value approach. Option D, cost approach. The correct answer is option A, income approach. The income approach is commonly used for income-producing properties because investors buy the expected income stream. Choice B is wrong because sales comparison uses adjusted sale prices of comparable properties. Choice C is wrong because tax assessments are not one of the three primary appraisal approaches. And choice D is wrong because cost analysis focuses on land and improvements rather than capitalized income. Question 66. For a duplex in Atlantic City, a buyer chooses a loan insured by the Federal Housing Administration. Which statement best describes the loan? Option A, the loan requires no underwriting. Option B, the loan is guaranteed by the Department of Veterans Affairs. Option C, the loan is made directly by the seller. Option D, the loan is made by an approved lender and insured by FHA. The correct answer is option D. The loan is made by an approved lender and insured by FHA. FHA insurance protects the lender and allows qualified borrowers to use FHA program terms. Choice A is wrong because FHA loans still involve borrower and property underwriting. Choice B is wrong because VA guarantees eligible veteran loans rather than FHA loans. And choice C is wrong because seller financing is separate from FHA insured lending. Question 67. While preparing a listing package, a buyer signs a promise to repay the loan and also gives the lender a security interest in the property. Which documents are involved? Option A, deed and bill of sale only. Option B, listing agreement and agency disclosure only. Option C, survey and appraisal only. Option D, promissory note and mortgage. The correct answer is option D, promissory note and mortgage. The note is the borrower's debt promise, while the mortgage secures that debt with real property. Choice A is wrong because a deed transfers title and a bill of sale transfers personal property. Choice B is wrong because brokerage documents do not create the borrower's debt and security pledge. And choice C is wrong because surveys and appraisals provide information but do not create the loan obligation. Question 68. At a salesperson training session, a lender requires private mortgage insurance because the borrower has a small down payment. Which purpose does PMI serve? Option A, it replaces the need for a promissory note. Option B, it protects the lender if the borrower defaults on a high LTV conventional loan. Option C, it protects the borrower from losing equity if prices decline. Option D, it guarantees that property taxes will not rise. The correct answer is option B, It protects the lender if the borrower defaults on a high LTV conventional loan. Private mortgage insurance is commonly required when lender risk is higher because the borrower has limited equity. Choice A is wrong because the borrower still signs a debt obligation. Choice C is wrong because PMI is lender protection, not market loss insurance for the borrower. And choice D is wrong because PMI has no effect on tax assessments. Question 69. After receiving an offer in Asbury Park, a lender provides the loan estimate and closing disclosure under Federal Integrated Disclosure Rules. Which topic is involved? Option A, a deed restriction. Option B, TRID disclosure requirements. Option C, a zoning variance. Option D, a broker price opinion only. The correct answer is option B, TRID disclosure requirements. TRID rules integrate federal mortgage disclosures so borrowers receive clearer information about loan terms and closing costs. Choice A is wrong because deed restrictions are private limits on property use. Choice C is wrong because a variance is land use permission from a local authority. And choice D is wrong because pricing opinions do not replace loan disclosure rules. Question 70. During an agency disclosure conversation, a creditor refuses to consider an applicant's income because of the applicant's marital status. Which federal credit law is implicated? Option A, Real Estate Settlement Procedures Act. Option B, Municipal Land Use Law. Option C, Truth in Renting Act. Option D, Equal Credit Opportunity Act. The correct answer is option D, Equal Credit Opportunity Act. The Equal Credit Opportunity Act prohibits discrimination in credit transactions based on protected factors. Choice A is wrong because RESPA focuses on settlement practices and certain referral issues, not all credit discrimination. Choice B is wrong because that law concerns local land use planning and approvals. And choice C is wrong because that is a New Jersey landlord-tenant disclosure law. Question 71. In a compliance audit, a title search finds an unreleased old mortgage that may affect ownership. What is this issue commonly called? Option A, a variance. Option B, a gross lease. Option C, a cloud on title. Option D, a functional obsolescence. The correct answer is option C, a cloud on title. A cloud on title is a claim, defect, or unresolved matter that may impair marketable title. Choice A is wrong because a variance is zoning relief and does not clear title. Choice B is wrong because a gross lease concerns rent payment structure, and choice D is wrong because functional obsolescence is a loss in value from outdated design or utility. Question 72. When reviewing closing papers, a buyer wants assurance against certain hidden title defects after closing. Which product is designed for that purpose? Option A, private mortgage insurance. Option B, hazard insurance only. Option C, title insurance. Option D, a home warranty only. The correct answer is option C, title insurance. Title insurance protects against covered title defects that may not be discovered before closing. Choice A is wrong because PMI protects the lender from borrower default. Choice B is wrong because hazard insurance covers physical damage risks, not title defects. And choice D is wrong because a home warranty addresses covered systems or construction issues, not ownership title. Question 73. Before meeting a client in Paterson, a deed is signed, delivered, and accepted by the grantee. When does title generally pass? Option A, upon valid delivery and acceptance of the deed. Option B, only when the property is advertised online. Option C, only when the buyer first tours the property. Option D, only when the listing agreement is signed. The correct answer is option A, upon valid delivery and acceptance of the deed. A deed transfers title when it is properly executed, delivered, and accepted. Choice B is wrong because advertising does not convey ownership. Choice C is wrong because a showing creates no title transfer. And choice D is wrong because a listing agreement authorizes brokerage services and does not transfer title. Question 74. During a transaction in Trenton, a deed contains no warranties and transfers only whatever interest the grantor may have. Which deed is most likely? Option A, bargain and sale deed with covenants. Option B, general warranty deed. Option C, quitclaim deed. Option D, installment land contract. The correct answer is option C, quitclaim deed. A quitclaim deed conveys any interest the grantor has without promising that title is valid. Choice A is wrong because that deed contains limited assurances beyond a quitclaim. Choice B is wrong because a general warranty deed provides broad title warranties. And choice D is wrong because that is a financing arrangement, not a deed type. Question 75. In a brokerage file review, a buyer records a deed promptly after closing. What is the main purpose of recording? Option A. To create the buyer's loan obligation. Option B. To set the zoning classification. Option C. To give public notice of the buyer's interest. Option D. To make an invalid deed automatically valid. The correct answer is option C. To give public notice of the buyer's interest. Recording protects the buyer by making the ownership claim part of the public record. Choice A is wrong because the note creates the debt obligation. Choice B is wrong because zoning is controlled by municipal regulation. And choice D is wrong because recording does not cure all defects in execution or delivery. Question 76. For a duplex in Hoboken, a lender forecloses because the borrower defaults and the sale proceeds do not fully cover the debt. Which term may describe the remaining unpaid amount? Option A, equity. Option B, accession. Option C, deficiency. Option D, estoppel certificate. The correct answer is option C, deficiency. A deficiency is the remaining debt when foreclosure sale proceeds are not enough to satisfy the obligation. Choice A is wrong because equity is the owner's value above liens, not unpaid debt after sale. Choice B is wrong because accession concerns property added by natural or artificial means. And choice D is wrong because an estoppel certificate confirms facts such as lease status. Question 77. While preparing a listing package, a seller owes more on the mortgage than the property is expected to sell for and asks the lender to approve a reduced payoff. What transaction is being discussed? Option A, installment sale with no lender involvement. Option B, short sale. Option C, adverse possession. Option D, tax assessment appeal. The correct answer is option B, short sale. A short sale requires lender cooperation because the sale price will not fully satisfy the mortgage debt. Choice A is wrong because a short sale specifically involves lender approval of less than the full payoff. Choice C is wrong because adverse possession is acquiring title through possession under strict requirements. And choice D is wrong because an assessment appeal challenges taxable value, not lender payoff. Question 78. At a salesperson training session, a tenant pays one fixed rent amount and the landlord pays most operating expenses. Which lease type is most likely? Option A, gross lease. Option B, net lease. Option C, percentage lease. Option D, ground lease. The correct answer is option A, gross lease. In a gross lease, the tenant generally pays a fixed rent while the landlord covers specified property expenses. Choice B is wrong because a net lease shifts some or all property expenses to the tenant. Choice C is wrong because a percentage lease includes rent based partly on business sales. And choice D is wrong because a ground lease usually leases land for long-term development. Question 79. After receiving an offer in Morristown, a retail tenant pays base rent plus a share of gross sales. Which lease type is this? Option A, percentage lease. Option B, graduated deed. Option C, gross lease. Option D, life estate. The correct answer is option A, percentage lease. Percentage leases are common in retail settings because rent is tied partly to the tenant's business performance. Choice B is wrong because that is not a standard lease type. Choice C is wrong because a gross lease uses a fixed rent structure without a sales percentage as the defining feature. And choice D is wrong because a life estate is an ownership estate rather than a lease. Question 80. During an agency disclosure conversation, a property manager holds rent deposits and security funds for an owner. Which duty is central to that role? Option A, using trust funds to pay personal bills. Option B, fiduciary accounting and safeguarding of funds. Option C, ignoring owner instructions whenever convenient. Option D, guaranteeing future property appreciation. The correct answer is option B, fiduciary accounting and safeguarding of funds. Property managers handle other people's property and money, so fiduciary care and accurate accounting are essential. Choice A is wrong because personal use of client funds is conversion. Choice C is wrong because a manager owes duties to the owner under the management agreement. And choice D is wrong because a manager cannot guarantee market value increases. Question 81. In a compliance audit, A leasing office refuses to provide a reasonable accessibility accommodation for a qualified applicant with a disability. Which compliance area is implicated? Option A. Only tax preparation. Option B. Fair housing and aid-related property management duties. Option C. Only capitalization rate analysis. Option D. Only fixture classification. The correct answer is option B. Fair housing and aid-related property management duties. Property management must comply with fair housing and accessibility requirements when dealing with applicants and tenants. Choice A is wrong because tax allocation does not address disability accommodation. Choice C is wrong because income valuation does not resolve accommodation duties. And choice D is wrong because fixture law does not excuse discriminatory leasing practices. Question 82. When reviewing closing papers, a seller says there is no need to disclose lead-based paint information for a home built in 1965. Which response is best? Option A. Lead disclosure applies only to vacant land. Option B. Lead disclosure is optional if the seller dislikes paperwork. Option C. Lead-based paint disclosures are required for many residential properties built before 1978. Option D. Lead disclosure applies only to newly constructed homes. The correct answer is option C. Lead-based paint disclosures are required for many residential properties built before 1978. Federal lead-based paint rules are a key property disclosure topic for older residential housing. Choice A is wrong because the rule concerns certain residential dwellings, not vacant parcels. Choice B is wrong because disclosure duties are not waived by convenience. And choice D is wrong because newer construction is generally less likely to trigger the federal pre-1978 rule. Question 83. Before meeting a client in Newark, a buyer asks whether marketable title and insurable title mean exactly the same thing. Which answer is best? Option A. Insurable title means the deed was never recorded. Option B. Marketable title refers only to zoning. Option C. They are related but not identical because a title company may insure some risks that still require review. Option D. They always mean no title issues exist anywhere. The correct answer is option C. They are related but not identical because a title company may insure some risks that still require review. Marketable title focuses on reasonable freedom from defects, while insurable title focuses on what a title insurer is willing to insure. Choice A is wrong because insurability does not depend on avoiding recording. Choice B is wrong because marketability concerns ownership title, not just land use. And choice D is wrong because even insured titles can have exceptions or exclusions. Question 84. During a transaction in Jersey City, a listing agreement gives one broker the exclusive right to earn a commission if the property sells during the listing period. Which listing type is described? Option A. Exclusive right to sell listing. Option B. Net listing. Option C. Option contract. Option D. Open listing only. The correct answer is option A. Exclusive right to sell listing. An exclusive right to sell listing gives the listing broker the strongest commission protection during the listing term. Choice B is wrong because a net listing pays the broker amounts above a seller's desired net and raises legal and ethical concerns. Choice C is wrong because an option gives a right to buy rather than appointing a listing broker. And choice D is wrong because an open listing allows multiple brokers and only the procuring broker earns commission. Question 85. In a brokerage file review, a buyer asks whether all commission rates are fixed by New Jersey law. Which answer is best? Option A. Only listing brokers may negotiate commissions and buyers never may. Option B. Commission is illegal in all residential sales. Option C. The commission sets a mandatory statewide commission. Option D. Commission rates are negotiable between the parties and the brokerage. The correct answer is option D. Commission rates are negotiable between the parties and the brokerage. Antitrust and consumer protection principles require avoiding claims that commissions are fixed or uniform. Choice A is wrong because compensation terms depend on the applicable agreement. Choice B is wrong because licensed brokerage compensation is permitted when properly earned and disclosed. And choice C is wrong because state law does not set a mandatory brokerage commission rate. Question 86. For a duplex in Trenton, several brokers agree not to charge below a certain commission rate. Which legal concern is most direct? Option A. Creation. Option B. Price fixing under antitrust law. Option C. Easement by necessity. Option D. Adverse possession. The correct answer is option B. Price fixing under antitrust law. Competitors may not agree to set commission rates because such agreements restrain competition. Choice A is wrong because prioration allocates expenses at closing. Choice C is wrong because that easement provides access to landlocked property. And choice D is wrong because adverse possession concerns acquiring title through possession. Question 87. While preparing a listing package, brokers divide a city and agree that each will work only in assigned neighborhoods. Which antitrust violation is suggested? Option A, substitution principle. Option B, a market allocation. Option C, tie-in survey. Option D, specific performance. The correct answer is option B, market allocation. Market allocation occurs when competitors divide customers or territories instead of competing freely. Choice A is wrong because substitution is a valuation concept. Choice C is wrong because that is not the standard term for dividing markets. And choice D is wrong because specific performance is a contract remedy. Question 88. At a salesperson training session, a buyer asks why due diligence matters before buying a property near the Pinelands. Which New Jersey topic is most relevant? Option A, only commission splitting. Option B, only fixture ownership. Option C, only private mortgage insurance. Option D, Pinelands Protection Act and land use restrictions. The correct answer is option D, Pinelands Protection Act and land use restrictions. Special New Jersey land use laws can affect development rights and permissible uses in protected areas. Choice A is wrong because compensation issues do not decide environmental land use limits. Choice B is wrong because fixture law does not control regional environmental regulation. And choice C is wrong because PMI does not address protected land use areas. Question 89. After receiving an offer in Princeton, a landlord must provide certain required rental information to tenants under New Jersey law. Which topic is most relevant? Option A, general warranty deed. Option B, eminent domain. Option C, real estate guarantee fund. Option D, Truth in Renting Act. The correct answer is option D, Truth in Renting Act. The Truth in Renting Act is a New Jersey landlord-tenant disclosure topic included in state law review. Choice A is wrong because deeds transfer title and do not provide rental notices. Choice B is wrong because eminent domain is a government taking, not tenant disclosure. And choice C is wrong because the fund addresses certain losses from licensee misconduct. Question 90. During an agency disclosure conversation, a buyer asks whether freshwater wetlands on a parcel can affect construction plans. Which New Jersey topic is most relevant? Option A, discount points. Option B, joint tenancy. Option C, the Freshwater Wetlands Protection Act. Option D, net lease. The correct answer is option C, Freshwater Wetlands Protection Act. Freshwater wetlands regulation can restrict development and require permits or approvals before construction. Choice A is wrong because discount points are prepaid loan interest charges. Choice B is wrong because joint tenancy is a form of co-ownership. And choice D is wrong because net leases allocate property expenses between landlord and tenant. Question 91. In a compliance audit, a buyer purchases a property for $425,000 and obtains a mortgage loan of $327,250. What is the loan-to-value ratio? Option A, 68.9%. Option B, 77%. Option C, 87%. Option D, 23%. The correct answer is option B, 77%. Loan-to-value is the loan amount divided by the purchase price, so $327,250 divided by $425,000 equals 77%. Choice A is wrong because that divides by the wrong property value. Choice C is wrong because that overstates the ratio by adding an unrelated percentage. And choice D is wrong because that calculates the down payment percentage rather than the loan-to-value ratio. Question 92. When reviewing closing papers, a borrower pays 3 discount points on a $310,000 loan. How much do the points cost? Option A, $12,400. Option B, $93,000. Option C, $103,333. Option D, $9,300. The correct answer is option D, $9,300. 1 discount point equals 1% of the loan amount, So 3 points equals 3% of $310,000, or $9,300. Choice A is wrong because that uses the wrong number of discount points. Choice B is wrong because that treats each point as 10% instead of 1%, and choice C is wrong because that divides by the point number instead of multiplying by the point percentage. Question 93. Before meeting a client in Asbury Park, a listing sells for $625,000 with a total commission rate of 5.5%. What is the total commission? Option A, $40,625. Option B, $3,438. Option C, $590,625. Option D, $34,375. The correct answer is option D, $34,375. Total commission is sale price multiplied by the commission rate, so $625,000 times 5.5% equals $34,375. Choice A is wrong because that uses a commission rate 1 percentage point too high. Choice B is wrong because that moves the decimal point incorrectly, and choice C is wrong because that calculates approximate seller proceeds before other costs rather than commission. Question 94. During a transaction in Montclair, a property sells for $640,000. The total commission is 6%, and a salesperson receives 55% of the brokerage's commission. What is the salesperson's share if this is the only split applied? Option A, $352,000. Option B, $21,120. Option C, $38,400. Option D, $17,280. The correct answer is option B, $21,120. First calculate the total commission of $38,400, then multiply by the 55% split to get $21,120. Choice A is wrong because that applies the split percentage to the sale price instead of the commission. Choice C is wrong because that gives the full commission before the split, and choice D is wrong because that gives the other side of the split. Question 95. In a brokerage file review, annual property taxes are $9,300 and the seller owes taxes for 155 days using a 365-day proration method. What is the seller's tax proration? Option A, $3,949.32. Option B, $5,350.68. Option C, $4,004.17. Option D, $120,125. The correct answer is option A, $3,949.32. Daily taxes are $9,300 divided by 365, and multiplying by 155 days gives $3,949.32. Choice B is wrong because that gives the remaining annual taxes instead of the prorated amount. Choice C is wrong because that uses a 360-day year rather than the stated 365-day method, and choice D is wrong because that treats days as months. Question 96. For a duplex in Jersey City, a buyer purchases a home for $590,000 and makes an 18% down payment. How much is the down payment? Option A, $135,700. Option B, $483,800. Option C, $8,850. Option D, $106,200. The correct answer is option D, $106,200. The down payment equals the purchase price multiplied by 18%, which is $106,200. Choice A is wrong because that uses the wrong down payment percentage. Choice B is wrong because that calculates the amount financed rather than the down payment, and choice C is wrong because that divides the down payment as though it were a monthly payment. Question 97. While preparing a listing package, a seller's sale price is $700,000, mortgage payoff is $380,000, and closing costs are $25,000. What are the seller's estimated net proceeds before other adjustments? Option A, $675,000. Option B, $320,000. Option C, $405,000. Option D, $295,000. The correct answer is option D, $295,000. Seller net is sale price minus the mortgage payoff and closing costs, so $700,000 to $380,000, $25,000 equals $295,000. Choice A is wrong because that omits the mortgage payoff. Choice B is wrong because that omits closing costs. And choice C is wrong because that adds deductions instead of subtracting them from the sale price. Question 98. At a salesperson training session, an income property has net operating income of $95,000 and a value of $1,100,000. What is the capitalization rate? Option A, 11.58%. Option B, 8.64%. Option C, 10.64%. Option D, 86.36%. The correct answer is option B, 8.64%. Capitalization rate is net operating income divided by value. So $95,000 divided by $1,100,000 equals 8.64%. Choice A is wrong because that divides value by income and does not produce a capitalization rate. Choice C is wrong because that adds an unrelated percentage to the calculation. And choice D is wrong because that shifts the decimal place incorrectly. Question 99. After receiving an offer in Camden, a monthly mortgage payment includes $1,940 for principal and interest, $660 for taxes, and $205 for insurance. What is the pity payment? Option A, $2,600. Option B, $2,145. Option C, $865. Option D, $2,805. The correct answer is option D, $2,805. Pity includes principal, interest, taxes, and insurance, so adding $1,940, $660, and $205 gives $2,805. Choice A is wrong because that omits insurance. Choice B is wrong because that omits taxes. And choice C is wrong because that omits principal and interest. Question 100. During an agency disclosure conversation, a rectangular parcel measures 155 feet by 108 feet. What is its area? Option A, 0.38 square feet. Option B, 263 square feet. Option C, 526 square feet. Option D, 16,740 square feet. The correct answer is option D, 16,740 square feet. Area is length multiplied by width, so 155 feet times 108 feet equals 16,740 square feet. Choice A is wrong because that converts to acres but labels the result incorrectly. Choice B is wrong because that adds dimensions rather than multiplying them. And choice C is wrong because that calculates perimeter instead of area.